Hey guys, today we're going to talk about penalty clauses. I'm sure most of you have seen contracts, DIY contracts, home drafted contracts, which contain penalty clauses. For example, if a supplier delivers a goods 1 day late, he has to pay $200. I've also seen employment contracts, employment agreements, that contain clauses such as if the employee resigns before 6 months, she has to pay $10,000. I've also seen employment contracts with non-competition clauses, which state that if the employee resigns and works for a competitor, the employee has to pay a $50,000 penalty. Now, to cut the long story short, penalty clauses are void and unenforceable. Because lawyers know that penalty clauses are void and unenforceable, when drafting contracts, they usually craft it as liquidated damages. Liquidated damages are recognized under contract law, are recognized by the courts. Liquidated damages are a genuine pre-estimate of losses that a party will suffer from the other party's breach. For example, if an ice cream seller makes about $200 in revenue a day and he decides to enter into a supply contract with an ice cream supplier, okay, he can put in a clause saying that if the ice cream supplier fails to deliver ice cream on time, okay, then the supplier has to pay liquidated damages of $200. Why is it $200? Because it's a genuine pre-estimate of the losses that the ice cream seller will suffer. Because he makes about $200 a day. So if the ice cream is not delivered, he loses $200. So it's a genuine pre-estimate. Sometimes, even if the clause is labeled as liquidated damages, a party being sued for it may challenge the clause that it is actually a penalty clause. If the party wants to challenge the clause as a penalty clause, he has the burden, okay, to prove that it is a penalty clause. This proposition was set out in the case of Banner Investments Private Limited and Hoseng Metal Fabrication and Engineers Private Limited. So how do you get around this challenge? So how do you get around people challenging that the clause is a liquidated damages clause? Well, nothing much you can do, but one thing you can do is to state in the contract that the parties agree and confirm and acknowledge that this amount is the liquidated damages amount is a genuine pre-estimate of the losses that the party A would suffer in the event of breach by party B. You can put that in, but that will not prevent the other party from challenging if he does want to challenge. So, how do the courts decide whether a clause is really a penalty clause? Well, in the UK Court of Appeal case of Dunlop Pneumatic Tyre and New Garage and Motor Limited, the court held that whether a clause is a penalty clause or a genuine liquidated damages clause is a question of the construction of the contract. Okay, the clause has to be judged at the time of making of the contract and not at the time of the breach. What factors would the court consider when deciding whether a liquidated damages clause is actually a penalty clause? Well, the clause will be held to be a penalty clause if the sum to be paid is extravagant and unconscionable in comparison to the greatest loss that the innocent party would suffer from such a breach. So, for example, if the greatest loss arising from the breach that the party would suffer from non-delivery of goods is $2,000 because he lost the chance to make $2,000. Then, if the contract states that a breach of not delivering the goods on time, they have to pay $10,000. That is clearly extravagant and unconscionable and would be held to be a penalty clause because it's not a genuine pre-estimate of the losses that the innocent party would suffer. Secondly, if the breach consists of non-payment of money, okay, and the liquidated damages clause requires payment of a larger sum of money, then it will be held to be a penalty clause. So for example, in a contract, one of the clauses states that Party A should pay Party B the sum of $500 on the 18th of July. Party A fails to pay the sum of $500 on 18th of July. And then the next clause say, if Party A does not pay the sum on 18th of July or pays it late, then he would have to pay $800 instead. So clearly this is a penalty clause because it's a higher sum when the payment involves the payment of a sum of money. There is also a presumption that a clause is a penalty clause when there is a payment of a single lump sum as compensation on the occurrence of one or more or several events, which some are serious and some are minor. So for example, the clause goes along the lines of Party A shall pay the sum of $10,000 in the event of A, B, C, D, E, F, G. In A, B, C, D, E, F, G, some of the breaches are major, material, some are minor, but they all involve the same payment of the $10,000. So it will be held to be a penalty clause. So what happens if the court finds that a liquidated damages clause is actually a penalty clause? Very simple. Instead of upholding the clause, the court will award damages, okay, for the actual losses suffered by the plaintiff. This was laid down in the English case of Jobson and Johnson, where the court stated that the classic form of relief against such a penalty clause has been to refuse to give effect to the penalty clause, but to award damages for the breach instead. So thanks for watching this video on penalty clauses.